Danielle Free. Miss Free, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On November 6, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it speeding 55 miles per hour in a 40-mile-per-hour zone in the 7800 block of Spencer Highway. Upon contact with the defendant, the officer detected an odor of an alcoholic beverage on the defendant's breath, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4. The defendant admitted to drinking and to taking prescription muscle relaxers on occasion. The officer located a case of twisted teas in the defendant's motor vehicle with 2 open cans of twisted teas, 1 in each cup holder. And
consuming while.
Okay, let's pause for a second. 2 open cans of twisted tea in the cup holders, and she admitted to drinking and taking prescription muscle relaxers. That's a serious combo. In most states, that's not just DUI, it could elevate to a DWI due to impairment from mixed substances. But here's the question, should honesty with the officer help her case or make it worse? What do you think?
Driving?
There were 2 open cans in the cup holders, yes, Your Honor. And DICs were read and the defendant consented to blood.
Ms. Free, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you not to drive. Do you understand? You are not allowed to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you consume alcohol, illegal drugs, unprescribed controlled medication, likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, Alex?
No, Your Honor.
Any prior criminal history at all?
She has a prior racing on a highway that was dismissed earlier this year.
What do you do for a living, Ms. Free? Why?
I just graduated nursing school, so I was a CNA and caregiver in an independent care facility. But right now I help take care of my great grandma, so it's just a lot at once.
So how do you support yourself? How do you eat?
I live with my grandparents and I help them take care of her. She can't take care of herself. She has dementia and a mental disorder.
I'll fill out an application for you. I need to know everything about you, how much money you make, what kind of car you drive.
Whoa, this judge isn't playing around. Notice how she keeps circling back to one theme: accountability. She's practically spelling out the roadmap: don't drive, don't drink, or you're going to jail. And that tough love tone? Classic probation court energy. It's harsh, but it might actually be a lifeline for Danielle before things spiral further.
Any source of income that you have, money in the bank, stocks, bonds, IRAs, I'll have you fill out an application, but I need to know everything about you. Don't just put zeros because I'm going to send it right back to you.
Yes.
Do you understand? And I'll see whether you qualify. Above all else, do not drive. Do you understand? There's no justification that you can give for getting in a car. Likewise, don't consume alcohol or drugs. If you have a problem, you better address it, because if you don't, I'm going to do it for you. Promise you're not going to like the way that I do it. You understand? Okay. Do you mind giving me an application, please? Morning, Mr. Singleton.
Good morning, sir. How are you?
Been wearing, it's Thursday, Friday Eve. Ready for the weekend,
Yes, sir.
So
See, you have decorations.
thanks. Well, it's all them.
Yes, sir.
Your lawyer has asked for me, or is asking for a bond reduction in your case, but my concern, and I guess my very, very primary concern, is public safety. You've got a lot of serious charges, and from what I see, your bond is now at around 200,000. You've got 2 open aggravated assault cases, and you got an assault of a family member with us. Our bond is set at 5,002. What did you guys want?
possibly looking for a PR bond, due to the fact that his other two cases are extremely high. We believe that he should be able to bond out on that. He has been in talks with some family members regarding possibly coming up with money for the other two bonds, but reducing it here would possibly help him out regarding the overall amount that he will have to come up with.
Well, so my concern is it looks like in September, he had an aggravated assault with a deadly weapon dismissed, right?
I believe that case got filed twice, and they.
So what's going on with the cases upstairs? And is it the same complaining witness as our case?
There's two complaining witnesses on those cases, Judge. And it looks as though it's a different complainant with us.
Is there a weapon involved? Is it a shooting?
On the aggravated assault with a deadly weapon, Judge, so in the felony cases, there's two weapons involved, a machete and a gun, a 9mm handgun.
Does he shoot at them? Does he shoot?
At them. So the state would be opposed to lowering bond, Judge, given the severity and the propensity to violence that felony cases also show.
Oh, I think I remember this case. It's about a neighbor, and it's either about like a fence or it's about some bushes or some, right? So,
The state's concern is community safety, Judge. So for those reasons, we would be opposed to lowering his bond.
Even if it's not going totally to a PR, if it's possible to do 2,500, that would be.
I don't know, I mean, we gave you a PR bond in this case. I let you out, right? And then you go out, you allegedly have these now two aggravated assault cases where in one, you point a gun at someone.
Shoot them in the head.
And if I remember, it's something so trivial over. Don't talk about the cases though, because I don't want you to.
I wouldn't incriminate myself or anything, but I live by truth, sir. And these people stole stuff from me.
No.
But Mr. Singleton,
Not that.
but there's a certain way when someone takes something from you, there's a certain way that you got to act.
I'm the one that
No.
called the police, Your Honor.
And that may be so, but there's still a certain way to act, right? And if you.
Washington?
Refresh my memory because I just don't remember it.
I can read.
Yeah, go for it. Just a brief synopsis.
On or about September 7th, 2024, complainant Sarver was in his truck when he was awoken by the defendant knocking on the window with a 9mm handgun. The defendant then pointed the gun at complainant Sarver and demanded that the complainant get out of the car. When complainant Sarver got out of the car,
Let's unpack that. 2 aggravated assault cases, a gun, a machete, all after he was already out on bond. That's why the judge isn't budging here. In bond hearings, prior behavior carries huge weight. The courtroom might sound calm, but this is a high-stakes moment. Freedom versus public safety. Be honest, if you were the judge, would you take that risk and grant bond again?
defendant stated that he would shoot the complainant in the head. Complainant Sarver advised that prior to coming home from work and having his incident with the defendant, the complainant too was also involved in an altercation with the defendant earlier in the night. The second complainant stated that an altercation arose between him and the defendant, which resulted in the defendant punching the second complainant in the face, causing him pain. The second complainant punched the defendant back, and the defendant ran to his house. Shortly after, the defendant returned with a machete in one hand and a stick in the other and was calling out for the second complainant to come out to the street. So it seems as though he pointed a gun at complainant one, and then in complainant two, he punched him, and then when the complainant punched him back, he came back with a machete and a stick.
Sorry, Mr. Singleton, it's just too dangerous for me, man. I can't give you a PR bond. I already gave you a PR bond. We'll let you out, and then you pick up these two serious cases. You know, if we give you a PR bond now, if we were to lower, I mean, what's going to happen? You're going to pick up a fourth case? We're trying to prevent that from happening. you know?
Understand?
Order in the court.
May I speak?
But not about the cases, okay? Just because I don't want you to hurt yourself, you know?
I understand, Your Honor, but I don't recall you ever giving me a PR bond, sir.
We gave you a PR bond on, in our case, we gave it to you on 8/12 of 24. I gave you a PR bond. We let you out of jail. You know, you had certain conditions that you're supposed to follow, no weapons, no contact with the complaining witnesses. And so here we are with two very serious cases. If you're able to bond out, and if you have someone, come back, talk, perhaps we can,
My fiance,
you know, but
the person who this is.
you're your own worst enemy, Mr. Singleton, really. I mean,
I'm
you're your
sorry.
own worst enemy.
I guess it's the military.
Well, don't blame it on the military. They're choices, right? And
Yes,
sometimes choices are made such that,
I know I need help, Your Honor. I'm not saying I don't need help. However,
the problem is that you can't do that after the fact.
I
You
understand.
got to recognize it before the fact, before it balloons out of control. That's why, you know, and it's not our first rodeo here with you. You've had prior assaultive cases like this. So you have to understand that when you get these feelings, these urges that you're going to lose, you got to try to take care of this beforehand. Now, why don't we have him TRAS'd? Okay, let's see what it says. Let's see how to go forward. You know, if they say that there's treatment that's, you know, I have options available to help you with these issues. And I'm willing to help you and I want to. Yeah, we will do it. But the first things first is I got to have you evaluated to see how we go forward. And if you let me do this, and if you're honest with me, Mr. Singleton, let's try to work something.
I will be.
All right. Can you set up a TRAS for Mr. Singleton? Yeah, please. I'm going to set you for an evaluation. I'm going to have you speak to clinicians. Be honest.
I will.
We'll come back in a couple days. Today's what, Thursday? Come back on Tuesday. Let's talk about how we go forward. Okay?
Yeah,
Look, this isn't the be all end all, but let's see how we go forward. You know, that's why God put eyes in the front. So we go forward. We don't go backwards. All
yes,
right?
Your Honor.
Okay. All right.
Thank you. Appreciate it.
Stay. Okay?
Uh,